Hey everybody, we are going to go through the exclusive right of sale listing agreement for transaction brokers for the Northeast Florida Association of Realtors. Keep in mind, this is the most updated contract, and you can look down at the date on the bottom right of each page, June 1st, 2020. All right, so we'll go ahead and get started. So the first thing you're going to put down here is line number 2. This will be the name of the broker. For our case, this will be Keller Williams Atlantic Partners, St. Augustine. Line 3 and 4 is going to be the names of the sellers, whether that be one person, two people, more than that, trust. You can check the property records for each county to verify who is listed as the owners of record. So you'll make sure to put that on line 3 and 4. Moving down to section 1. This is the grant of exclusive right to sell a property. This will be the time frame. So standard time frame is about 6 months. Starting date would go here. Ending date would be here. Keep in mind, if it is a land listing, you would not use this document, but you would put a longer time frame than 6 months, and same thing if it was a luxury priced listing, a little bit longer of a time frame, as the market for that is a little bit smaller. Moving down to line 21, this property is or is not the seller's principal residence. So you'll check depending on what the status of this property is, and then of course the initials of the seller. Moving down to section 2, property description. Again, you can verify all this information on the property records website. Street address, city and zip code, Clay County, or sorry, not Clay, whatever county it is in Florida. I live in Clay County, so it's a habit. Property tax ID and or the parcel ID, same thing. And then your legal description of the property. Keep in mind, some websites, some property record websites will state, click here for legal description. Make sure you click that and find out what the actual legal description is, as it could be different than what you're looking at on the home screen of this website. And then if a mobile home is included, the VIN number would go here. Section F, personal property. Some items are already standard to stay with the home. Sometimes you'll need to check extra items. Keep in mind, refrigerator has an S here. So if you have 2 refrigerators, one in the house, one in the garage, etc., if you check this, both would stay. You know, security cameras, smart home devices, other items would go here. But down here, line 48 and 49 would be where you exclude items from the listing agreement. So if you click refrigerators, but down here you put does not include garage refrigerator, then we now know the inside one will stay, the garage one will not. Moving down to section 3, these are the terms that the seller has agreed to. Listing price would be line 51. Keep in mind that if anything changes with the listing price, review paragraph 4 again, and you will need to have the seller's initial for this first listing price. Section B, method of payment. These are items that the seller has agreed to. Cash, conventional, VA, FHA, USDA, seller financing, or mortgage assumption. So you will need to go through what this, or go each one of these and verify that the seller is okay with them. Moving down to seller's expenses. Certain expenses are already a given as to what the seller will pay. Closing costs, including deed stamps, owner's policy, title search, etc. However, here you can also offer to immediately pay a home warranty or anything else that the seller is willing to pay. This is a conversation you'll need to have with the seller as to what to put here. Most sellers are probably not going to want to advertise that they're going to give money right up front unless they absolutely have to. Moving down to E, possession. Either the first line, 83, buyer will be given possession at closing. Means the day of closing, buyer gets the keys. Or 84, buyer will be given possession within X days after the date of closing. So this is when the seller needs some time to actually, actually get out of the property. Line 89, seller represents that there's no parties in possession other than the seller, meaning if the seller lives here or it is not rented to anybody, this would get checked. Line 91, if the property is rented or it is being advertised for rent, this would go here. And then line 98 through 100 would need to be filled out. Expiration date of the lease, either with no tenant option to renew or a tenant option to renew. Rent is due on this day of the month in this amount, and security deposit is this. So you need to fill this out if the property is rented. Moving down to section 4, financial representation. Line 112 states that the property or the sale of the property will produce sufficient funds to pay off the mortgage. Or line 115, there are no available funds and it will not produce enough money to pay off the mortgage. Therefore, it becomes a short sale. And then all the addendums that would qualify for that need to be included. If the property was acquired through a foreclosure, this is where you would advertise that. If the seller authorizes it or does not authorize to disclose that information. Moving down to broker obligations. This first section, line 127, is the use of the NEFAR lockbox system. So they either consent or do not consent, and their initials would go here. Section B, once you're under contract, this first, this first box would withhold verbal offers, or the second box withhold all offers, verbal and written. Seller would again initial here. Section E, electronic display. This first box, line 158, is the seller allowing the broker to advertise without restriction, except anything deemed confidential by any FMLS. Or this next one, they authorize all listing content related to the property on any electronic display without restriction, except that information deemed confidential by any FMLS and the street address. Or section 3, seller does not authorize broker to display anything whatsoever. And again, the initials. Section or line 170 through 174. Line 171, seller does or does not allow an electronic display to perform an automated valuation model, estimate of the market value of the property, or link to any display to obtain such estimate. And then line 1673, seller does or does not allow third parties to write comments, reviews, or blogs concerning the property or link to an electronic display to obtain such comments, reviews, or blogs on the electronic display. So they do or do not allow evaluation, and they do or do not allow comments and reviews. Section 6, seller's obligations. Line 194 actually starts up at line 192. Seller is obligated to execute a statutory general warranty deed, trustees, personal representative, or guardian's deed as appropriate to the status of the seller unless otherwise specified here. So the seller will give a statutory general warranty deed, one of these other ones, unless they state otherwise. Line 200, this property does or does not have an active audio surveillance system, and does or does not have active video surveillance. So audio, video, does or does not. Moving down to line 204 through 215. Property is subject to the following. You've got HOAs in the amount of this per month, or sorry, the name of the community, blank dollars per time frame and who it's paid to, master association fees, assessments for name of the community, amount, time frame, and who it's paid to, capital contribution or to homeowners or condominium association in the amount of, condominium association fees, maintenance assessments for name of the community in the amount of per the time frame, and again payable to, condominium or homeowners association special assessments in the amount of per time frame, CDD fees assessments in the amount of blank per year, and then lastly, government public body special assessments specifically and what it's for in the amount of and per the time frame. Some of these seller will know. Some of them you'll have to do a little bit of homework on to find out. 216 through 220. This is going to be the name, address, phone number, and email for each association to which a fee or assessment must be paid. This one right here, underline 220, a right of first refusal or option to buy the property by the condominium or homeowners association or anyone else. So if that condo has a first right to buy before anybody else, you'll need to check this right here and do the homework related to it. Line 224 through 232 is all about the compensation for the broker. So read through this. This first area is a flat dollar amount. If there's any sort of fees that are getting added on, it'll be right here, and a blank percent. So it's these two together of the purchase price, or a flat dollar amount, whichever is greater. And then here it breaks down for the other side. So this percentage right here is going to be the total percentage. So if the seller is getting 3 and the buyer is getting 3, buyer side, excuse me, then you're getting 6%, and 6% would go right here. And then down here would be the other percentage. So line 230, the other side for the buyer side would be blank percent of the purchase price, or a flat dollar amount to a single agent. Line 231, blank percent of the purchase price or blank dollar amount to a transaction broker. And then lastly, blank percent of the purchase price or a dollar amount to a non-representative broker. These right here will very rarely add up to this number up here, because again, this is only the buying side, and you will only ever have one of these included. So if I've got 6% here, I would do 3, 3, and 1. So while this adds up to 7, if I've got 6, I'm already getting 3 from my side. And then the other side would get the 3 to a single agent, 3 to a transaction, or 1 to a non-representative. Moving down to line 251. In the event the property is rented or leased during the term of this agreement or within 12 months after termination of this agreement to any person or entity to whom the property has been shown during the term of this agreement, including any extensions hereof, seller will pay broker a rental or leasing fee of blank percent of the gross rentals paid or to be paid, or a flat fee of blank, whichever is greater. So if this property gets rented after your agreement or even during the agreement, seller will still pay the broker based on these two numbers. Section 9 is all about damages. Seller and broker acknowledge that damages suffered by broker in the event seller cancels this agreement or otherwise prevents performance hereunder prior to broker finding a buyer ready, willing, and able to purchase the property are unascertainable at the present time, and that broker will incur damages such as expenses for overhead, advertising, transportation, and time. Accordingly, in the event this agreement is canceled by seller or seller otherwise prevents performance hereunder prior to broker finding a buyer ready, willing, and able to purchase the property, seller agrees to pay the broker on demand as liquidated damages blank percent of the then current list price or a blank dollar amount, the same being bona fide, fair, and reasonable, and as a result of arm's length negotiations. So if the seller cancels it, you do have the right to charge them a percent or a flat dollar amount. Section 11, material facts and defects. Seller represents that seller has no knowledge of facts materially affecting the value of the property other than those which a buyer can readily observe, except, so if there's anything here that the seller knows about that would affect the value, go right here. Seller further represents that the property is not now and will not prior to the date of closing subject to a municipal or county code enforcement proceeding, and that no citation has been issued except, so if there's anything that contradicts that, it would go right here. And then down here, the property is not in compliance with governmental owners association regulations permitting, except right here. So the seller knows of no issues with any of that. That would go, unless that would go here. To the best of seller's knowledge, the property was or was not built prior to 1978 and is or is not located either partially or totally seaward of the coastal construction control line. You can Google this line right here and it will show you where it is on the state map. All right, down in here, section 14, line 339. This is going to be any additional terms and conditions that the seller would like put in. Go ahead and write them in here. Mark if the seller is not a U.S. citizen or resident alien. And then you've got seller's printed name, their marital status, and the signature with the date. 4 sections for that. Preferred contact information for the seller, name and mailing address, email and phone number, and then the broker's firm name, listing phone number, listing office phone number, listing office address, signature of the listing licensee, date, listing licensee phone number, printed name of listing licensee, and then the listing licensee email address. So that has been the exclusive right of sale listing agreement for Northeast Florida Association of Realtors.